Hi, I'm Robin Hinshaw. I want to talk to you a little bit today about estate planning and your concerns for estate planning and exactly how our office handles the estate planning and addressing your concerns. The first and most important thing in handling your estate planning is to determine what your intent is. Who do you want to leave your property to? What property do you want to leave it to them? And how do you want to get it to them? Once we determine what your intent is, we want to address four major concerns that all clients have. And those are, number one, how do I avoid taxes or eliminate taxes? How do I keep Uncle Sam and the Department of Revenue completely out of the picture? Second thing is, how do I keep courts and lawyers out of the picture? Obviously, my clients love to hear me talk about that. In 38 years, I've yet to find a client that wants me more involved and charge them more money. The third concern is, how do I protect my heirs and beneficiaries from the claims of creditors, in-laws, and others? I want to talk about that. And the fourth thing is, you want to be able to select those persons that you wish to have that are handling the important things in your estate planning. You don't want others from outside addressing those issues. Let's talk about the first concern first. Taxes. A lot of things have changed in the last few years, and all have been good for my clients. First thing is, the North Carolina legislature abolished the death tax in North Carolina several years ago. Secondly, as far as the federal estate tax is concerned, there's been a continual increase in the amount that you can leave to your heirs and beneficiaries tax-free. That amount, now adjusted by inflation, says that you can leave up to $5.43 million each to your heirs and beneficiaries. There's still an unlimited amount you can leave to your spouse, and then when you leave it to your children, you can leave up to $5.43 million. Very few people have tax problems these days. We're not going to look at that in any detail. The second thing is probably the one thing that has been most improved upon in the last 5 to 6 years, and that's how to avoid probate, and how to avoid having courts and lawyers interfere with your estate. Most of my clients come into my office thinking that drawing up a will is a panacea for everything that happens. Nothing could be further from the truth. A will is one instrument or tool in passing your property. You want to leave your property to your heirs and beneficiaries with the least amount of hassle and the least amount of cost. Unfortunately, a will is not a very efficient vehicle because, again, wills are drawn up by attorneys and it has to be recorded with the courts once you die. Therefore, you would incur probate fees and potentially attorney's fees in doing so. There are a number of other ways to pass your property that are much more simple and elegant and less expensive. For example, you probably have joint bank accounts. At death, the bank or the credit union where you have that joint bank account could care less what's in your will because you have a contract with them saying that upon the death of one of us, it passes to the other. There are a number of other ways to pass property. Beneficiary designations, which you have in life insurance, annuities, IRAs, retirement plans. Those are very efficient ways, which again, as long as you name a beneficiary, do not pass through your will. I'm not saying you don't need a will necessarily or a trust. I'm saying that in most cases you want to minimize or in some cases eliminate the property that passes in that way. Drawing up a will or a trust is simply not enough. You're going to have to coordinate the passing of your assets with any will or trust that you draw up. In my practice, I tell clients routinely that drawing the will or trust up is about 40% of the process. 60% of the process is how you structure your assets, the ownership of those assets, and how your beneficiary designations are structured. So many times I see clients who come in and have wills where they've drawn up nice, neat trusts for their children or other beneficiaries that protect them from claims and creditors until they're the age 21 or 25. First of all, I think that's much too young. As I tell my clients also, between 20 and 40, we all make a lot of mistakes learning how to get to this world. But the biggest problem is, even though they've drawn up a will or a trust that says that the property is to go to the will of the trust, guess what? They have beneficiary designations directly to their children, or their bank accounts are set up to pass that way. Guess what happens? It doesn't actually end up in the trust. It ends up going through the probate process. And then perhaps, or in some cases, it will not end up in the trust. It'll go directly to the kids who in a lot of cases are much too young or immature to handle the property. We'll talk about that when we talk about the next thing. So again, the key to avoiding probate is making sure things do not pass through the courts and through the attorneys. The third thing we want to talk about is how to protect your assets. Recent changes in the laws, actually in 2006, 2007, we adopted the Uniform Trust Code in North Carolina. Uniform Trust Code provided that if a trust provides that the methods for distribution or the standard for distribution is for medical care, education, support, and maintenance of reasonable comfort, those are the magic words, then that trust is discretionary. And what that means is that you cannot force the trustee to exercise the discretion in favor of a creditor, an in-law, and even potentially bankruptcy. What that means is that if you put property in trust and leave it in trust, then no one else can reach that except for the beneficiary. And finally, the law was changed to state that even if the trustee is a beneficiary of the trust, you cannot force that trustee, the individual, to exercise it in his own favor, to pay off creditors, to be provided for in a divorce, or other concerns. You may also have a concern that you're in a second marriage and you want to make sure that your property goes not necessarily to the children by a previous marriage of your second spouse. In that case, you would set up a trust for your spouse and provide that they would be taken care of during their lifetime for medical care, education, support, and maintenance, but at their death, you direct it to your children. In this way, if you provide that the children become the trustee at a certain age. For example, in the past, we used to draw up trusts that provided for distributions at ages 21, 25, and 30, for example, 1/3 each of those ages. That's fine, but what if that child was in the middle of a divorce, had a judgment, or in the middle of a bankruptcy at the time that you died and the property became vested or passing to them? It could end up in their accounts and be seized by the creditor, the spouse, or someone else. Instead, you create the trust for the child and you provide that at a certain age that child will become the trustee and can then manage their assets, and under the law, even if they're their own trustee, they can't be forced to pay that out to a creditor or for some other involuntary purpose. The fourth thing is selecting who you want to take care of these things. You get to select who the trustee and the executor, and we're going to talk about powers of attorney and healthcare powers of attorney in a moment. You get to select who that is, and you don't want third parties. You typically want families, loved ones, or trusted individuals to do that. And you get to select those people who can do their job without interference. Now, that's a brief synopsis of taking care of the initial part of the estate planning process, drawing up a trust or a will, and then providing how that property gets to those beneficiaries. In our office, we like to say that we want to create it so that all the executor has to do, they do not have to qualify. All they have to do is record the will at the courthouse, and in the case where real property is involved, they would have to do a probate without qualification, which means there is no executor qualified, but they record the will, pass this title of property, and then we have everything else structured, beneficiary designations, PODs and TODs, which are payable on death for bank accounts and transfer on death on securities accounts, so that it's going not again to the executor, but it's going to a trustee or to an individual who will receive it directly. All they have to do is present a death certificate to the bank or other financial institution, and you have a contract and they have to pay it to that individual. Hence, the only thing that we have going through a will typically will be real estate on the second party to die. Real estate never goes through the probate process, and that's the one asset we want to have pass through your will, or that does pass through your will. Otherwise, we want to have all the financial assets set up so they're directed to the spouse or other individuals, or to a trust for those individuals. If you want to protect them, you have to direct it to a trust. The second and third things you need are powers of attorney for financial affairs and a durable health care power of attorney for medical affairs. A lot of people talk about living wills. In my opinion, they're out of disfavor because technically they provide that the physician makes the decision, and you want to select those people who will make health care decisions, and you also want to appoint people who manage your financial affairs through a power of attorney, so that it's someone that you trust implicitly and explicitly to carry out your wishes. Old healthcare powers of attorney, you need to examine carefully to make sure they have gifting provisions. This can be important in the case where you might become institutionalized and it might be necessary to transfer assets, and without powers to make gifts, you can't do that. That's one thing you need to look at in your existing documents. Healthcare powers of attorney, again, you want to make sure that they have unfettered ability to make all decisions. You want them to be able to say yay, nay, or take it away as to any and all medical procedures. And you want something that's flexible enough to take into consideration treatments that are in existence now and treatments that will come down the road. Medical science is making vast improvements in what they do and how they keep you alive these days. So those things you need to look at consistently and have it reviewed. In our office, we do not charge for initial consultation. In fact, we'll be glad to review your documents at no charge if you wish to fax them or email them to our offices with your wishes as to what needs to be done or what you're looking to have changed. All you have to do is call the office and set up an appointment. We'll be glad to sit down and we will tell you exactly what our recommendations are, and in writing, tell you what those recommendations are, and in fact, talk about cost. My clients don't like surprises, and I'm sure you don't either. There are no surprises. We sit down, we talk to you, there's no charge. We will then tell you in writing exactly what needs to be done and how much it will cost you. So at the time you leave, you'll know what we recommend and what the costs are. We would love to help you with your estate planning needs and be honored if you would allow us to do so.